and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yeah.
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything.
Can ask him to either redo it or I can, yes ma'am, I can get it in there.
Okay.
I will do that.
Okay, let's see. You are Gabrielle Smith? Stand up, please. And this is cause number 25, DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct? Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the other one? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now before trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
Yes, sir. Just here. Ready to get my charges, I guess, decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
That's 2-3, yeah, but 2-3 DC or 10-30.
Like, such a big crooked in the middle box. Okay, let's see.
Every time anything.
So, it looks like okay, there was back in February of 2024, there was a bond forfeiture. So the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She then entered a plea, Your Honor.
Entered a plea.
PSI bond.
I did
That
at
plea was
one.
rejected by the court.
Okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess.
for PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out. Okay. And then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000, so I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report
court revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you were rejecting that.
Right. And several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at $40,000 on a robbery with that criminal history. Okay. Mr. Nicholas, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. Involved a vehicle. I think the officer had leaned into it and then the vehicle went into motion. And,
How did the vehicle go into motion?
Well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
He scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about, I suppose.
So over here in a car with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got speedy trial, I guess, so we need to try.
We're in the 252nd, everything's speedy.
All right,
It will be placed, I mean, it wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all the,
I guess if this court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
You take 8.
Take 8. You want me to do a rejection?
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Okay, again, you're Gabrielle Smith. And Ms. Smith, in cause number 25, DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer from June 10th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Judge,
And I think-
nothing's been filed at this point, but I know with the number of priors she has and a note on the file that the priors have been ordered, I do anticipate there'll be a notice. I forget if it's Mr. Smith or Mr. Muffin, but I know they intend to enhance it.
So I want to make sure you also understand, and I'm going to make a notation on here. If any of those prior offenses out of Louisiana, the felonies, were at different times, and one conviction happened and then another conviction happened later, that means you could be considered a habitual offender and with a minimum punishment of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
Also, just in case they're not one after the other, if you have one prior felony conviction, then, okay, it doesn't do anything. Right, this is a second. All right, so if you have two sequenced, it would make you habitual. Do you understand?
If she has one, it would boost her up to a first.
Yes, sorry. So if you have one,
And I understand what they mean.
okay, so listen very carefully. You have several felony convictions out of Louisiana. Okay, so if just one of those is true, then your punishment range in this case, if you're found guilty, becomes that of a first-degree felony instead of a second. So that means it would be from 5 years minimum up to 99 years or life if there's one prior conviction. You understand? Answer out loud. So
Yes, ma'am.
okay. If there's 2 prior felony convictions that happened, not all of the, I know there were several that happened at the same time, right? But I'm not sure, but it looks like there might be another set that happened later. If that is true, and there are 2 that happened at different times, then it means you could be considered a habitual offender here in Texas. And if that all is true and you're found guilty, then your minimum punishment is 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
Okay. And it looks like what the state has offered, if you wanted to enter a plea of guilty, would be to go on count 1, which is just the offense that you're charged with now, for an 8-year term in prison. You have every right to reject that and have your case go to a jury, let them decide if you're guilty or not, and then let them decide your punishment depending on what they find on those priors. I just want to make sure you understand what your options are if you wanted to plead guilty for that 8 years and what your possible consequences are if you go to trial. Do you understand all of that?
Same.
Okay, and do you want to reject that offer and have your case set for trial?
Yeah, I want to check.
Okay, and I do want to make sure you understand, Ms. Smith, that after today, unless there is new information or evidence that comes up that the attorneys don't know about at this time, I will not accept this plea agreement after today. So if you change your mind, it's not going to be to the 8 or something less later. It's going to be something different. Once a case goes on my trial docket, it goes to trial. So it's not, we're buying time to try to get some better deal. This is the deal. That's fine that you don't want to take it. I do want to make sure.
I have to. So I can't think on it and come back.
You can think on it and come back next week.
Okay, that's fine.
1 week, you'll leave it open?
Yes, Your Honor, I'll leave it open for good reason.
You have to decide by next week, knowing all of that. Nothing's going to change between now and then. So now you know everything. Think about it. Talk to any family members that you need to. We'll have you brought back next week and you can decide, okay? I'm going to delete this rejection. If y'all do it again, you'll have to do it again. Okay? All right, ma'am. Are you Kyla Allen?
Yes, ma'am.
And this is 23 DCCR 0639. Ms. Allen was placed on probation October of 2023 for evading arrest or detention with the use of a vehicle. In court, previously entered pleas of true and a motion to revoke probation to counts 1 through 10. I've received that updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. State yes, Judge.
Are there any additions or corrections to that report?
No, Judge. Not from the state, Judge.
And this is unagreed. Mr.
Correct.
Parker, you may proceed.
Your Honor, all I can say is, these violations are all technical, even though, I understand that they're still serious and you have to follow the rules of probation. She's young. She's 19 years old. I think being in jail has opened her eyes, and she wants to complete probation. She has quite a bit of time behind this, and my deal was, take the time. She said, I don't want to do it. And she's sincere. She says, I want to prove to myself and prove to everybody else that I can complete the probation. And she has the opportunity. She has a job waiting for her. She gets out, and she's requesting this probation, and she'd like to address it for the judge.
Go ahead, ma'am.
I just want to say I own up to all my wrongdoings. I do. I know it was wrong. I knew it was wrong when I was doing it, and I regret it. But I want to prove that I can do better, and I'm not the person that I got to be. I'm young. I want to build my relationship back up with my people, make it stronger, build my trust. Just do the right thing. Make it right before it's too late.
Thank you, ma'am. Mr. Coleman?
Your Honor, this is Mr. Smith's case. I'm under the understanding that Mr. Smith made a 3-year offer in this case. I am cognizant of the fact that recommendations from probation department on the last page states that while the defendant's violations are mainly technical in nature, this officer is not inclined to recommend continuation of supervision at this time. So with that, my position is the same as Mr. Smith, that shooting results in some jail time.
Ms. Lopez, do you have anything to add other than what's in the update? So, Ms. Allen, the only thing that I'm inclined to do if I continue, I mean, you are young. You don't have a lot of criminal history. This is your first felony, no misdemeanors. Of course, you're young, but you were actually certified as an adult for this, which is, I don't know, certifying on an evading is a little, I guess it's because she was so close to age, but still, that's. So here's the thing. You're not going to go home today, okay? If I continue you on probation, which you don't want a felony conviction. At this age, it changes your life in a very negative way, but you obviously need some, in my opinion, just a little more help to make better decisions. And so what I'm going to do is find that you entered your pleas of true to counts 1 through 10 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and send you to prison. I'm not going to do that today. I'm going to continue you on probation, but I am going to order that you now enter and successfully complete the cognitive track of the ISF program. So you went to the substance abuse track so that you could get tools to stay clean. This track helps you make better decisions, helps you grow up. It's hard at 19 to make the decisions that you need to make to be able to stay on this probation, and this is meant to help you. And so you'll go from jail to that program, you'll get out, you're still going to be on probation. You will be on zero tolerance probation. That means if you make another mistake, Ms. Lopez is going to send something over. There's going to be another motion. I'm going to look back at this. Mr. Coleman and Mr. Smith are going to remind me that they asked for prison time this time, and it's probably not going to be the 3 years. Do you understand?
Yes, ma'am.
I hope you take advantage of this opportunity. All right? Good luck to you, ma'am. You can go back with the bailiff. Come back for a second.
Jail.
Well, I just want to make sure of something else. I want to make sure you understand something else. That if you get incident reports in our jail or in ISF, that will be a violation of your probation. And you may not ever make it to ISF. So if you are you're going to say things to the correctional officers, not do what they say, and tell them that you don't care about getting a write-up, but say those things in a lot worse ways, then you're going to go to prison. And you're not going to go to prison for 3 years. They're just there doing their jobs. If you follow the rules, they'll probably leave you alone. If not, their job is to make you follow the rules. And if you can't follow the rules in our jail, then I don't assume that you can follow the rules on probation, which you're kind of showing a pattern here. So it's time to grow up, change all that, or you're going to prison. It's that simple. Understand? Okay, go back with the bailiff.
On the
I
motion,
did
Your Honor?
second degree.
No, are they all
But
the
the
new
state jail
cases?
that's enhanced and
The state jail requires its enhancements.
That's the possession?
Yes, sir. Well, there's two possessions, Your Honor.
I'm thinking about
No,
it.
the evading arrest with previous convictions.
I'm just now thinking I may have filled out the state jail paperwork wrong. I'm not positive, but I may have.
Just be patient with me as I pull it, and then I'll figure out what we need to do, if anything. Okay, are you Kendrick Williams?
Yes, ma'am.
And will your client waive the formal reading of the indictments and also the motion?
He will, Your Honor.
Okay, so there are priors listed, so it is count one. I'm assuming,
Yes, Your Honor.
at least on the 1075.
But it's not needed. 1075 or 2352.
Okay, just 1076 today.
Yes, Your Honor.
Okay. In cause number 24, DCCR 1075, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of possession of a controlled substance from February 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? Give me just a second. In cause number 24, DCCR 1076, you're charged with a state jail felony offense of evading arrest or detention with previous convictions. And is he getting state jail time on
No,
this?
that's what I think.
So the offense date on this is from February 19th of 2024. The indictment alleges you were previously convicted of evading arrest or detention September 26th of 2007. It further alleges that you were previously convicted of possession of a controlled substance, a state jail felony, September 24th of 2007, and also possession of a controlled substance, a state jail felony, September 4th of 2012. And how do you plead to that charge? And are all of those prior offenses convictions true?
Yes, ma'am.
Okay, let me make that note real quick. This is so much better than paper. Okay, and then in cause number 24, DCCR 2352, you're charged with the second-degree felony offense of injury to a child, elderly, or disabled individual from July 19th of 2024. So that's already a second. Are we going on to the other counts as well,
We
or
don't
no?
need to, Your Honor, just count one.
So in that count one only, how do you plead to that charge? And again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In all three of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in those 3 cases.
No objection, Judge.
It's admitted in each of those cases. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in cause number 24 DCCR 1075, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You did it right.
I did? Okay.
And cause number 24, DCCR 1076, I'm also going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And in that case, find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2352, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now let me get the MTRP pulled up.
And Judge, counts 1 and 2 include some of the cases we just pled to. The third one was not yet added as an amendment, but since we had an agreement, we'll just go on 1 and 2.
1 and 2, okay. All right, in cause number 21, 36841, I have a motion to revoke your community supervision. It shows that you were placed on probation October 13th of 2021 for the offense of assault on a peace officer, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense that we've already talked about of evading arrest or detention with previous convictions, February 19th of 2024. And is that true or not true?
Yes, ma'am. Sure.
And then count 2 alleges that you committed the offense of possession of a controlled substance, February 19th of 2024. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I'll also have here on the computer in that case some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these papers with Mr. Parker?
Yes, ma'am.
And do you fully understand them also? And you understand if I follow this agreement, you will be waiving your right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all.